she won't be here Friday, so I think Friday, therefore, Taylor would be a good day to have our third test. And, but I wouldn't worry about it, Matt, because that's not till next month, so. Plenty of time to think about it. Angela was my star student in legal environment last semester, which, and her knowledge of the Commerce Clause, and you know it inside out, don't you?
Absolutely.
Her knowledge of the Commerce Clause qualifies her to be a camera operator. Linda, what are we looking for? We're looking for
CPA questions?
CPA questions. Which ones?
Corporation.
CPA questions. I need to come up with a better naming mechanism. These them? So make a note to yourself. Come up with a better naming. Make a note.
I'll write it down.
Alex, President Company has assigned a $10 million contract with a construction company to build a new corporate office. Which of the following corporate documents set forth the scope of authority? Well, it seems like, Linda, I can eliminate the proxy statement,
Yes.
since it has nothing to do with authority. Also, it seems like to me, Alex, the certificate of incorporation and charter are more broad and more general, while the bylaws are more specific. So therefore, Alex's answer is C, as in charter. You agree?
Yes.
Very good. Question 2. Question 2. David, the principle that protects corporate directors from personal liability for acts performed in good faith and for the corporation known as the Clean Hands Doctrine, the Full Disclosure Rule, the Responsible Person Doctrine, or the Business Judgment Rule. The answer is AJ, you agree. AJ, also it's interesting that the majority of American corporations are incorporated in Delaware. Michael, you knew that, didn't you? You told me last time you knew that. So AJ, why is that?
I remember you told us, I can't remember why though.
Well, I'll tell you why, and the next time I ask you, you will know.
Okay.
Why, David?
Because they have less liability, or more protection.
More protection for the board of directors, and therefore it's more difficult to sue them. And the business judgment rule, Linda, applies in all states, but it has more protection in the state of Delaware. Question number 3. Michael, which of the following actions are required to ensure the validity of a contract for incorporation and director of the corporation? So here we have a director who is here. Here's the corporation. Here's the director. And the corporation is engaging in a transaction with the director. To buy, I don't know, to do what, Michael? Maybe to rent an office, maybe to buy a fleet of vehicles, maybe to provide, for the director to provide a service. So Jody, in order to make this legit, an independent appraiser must render to the board of directors a fairness opinion. I don't know what a fairness opinion is, but it seems like, and Jody, would this be, and you suppose that we were a corporation in a small town like Kirksville. Do you think that it would be common or uncommon that a corporation would deal with an entity either owned or controlled or influenced by members of the board of directors. Would this be common?
I would think
Yeah, it would be fairly common. Even in a place like St. Louis, it would be common. So it seems like A is too extreme. B, the director must disclose the interest of the independent members of the board and refrain from voting. Or C, Michael, the corporation must review and ratify the contract. Put this to a vote of all shareholders. Or D, the director must resign. He's like, well, I can't do this. So it seems like C, A, C, and D are too extreme. So Michael, the answer is B. B is in boy. Joe, do you agree?
yes.
Question number 4. Taylor. I apologize for giving you an easy question. What is the doctrine in which corporations made liable for the torts of its employees committed within the scope of their employment? And Taylor, that is
The
respondent superior. Answer is A, in the apple. I'll give you a more interesting question later, I promise. Maybe on Friday, which is next month. Of the revised Business Corporation Act, which of the following dividends is not defined as a distribution? Brandon, this is a challenging question. Cindy, you agree? So let me think about this. Brandon, in a cash dividend, what is it we give shareholders? We give them cash,
Cash.
which is an asset. Cindy, when we give them, what's a property dividend?
Giving them property.
Like inventory, land, plant and equipment, building, which is also an asset. Now, Brandon, what's a liquidating dividend? Corporation's going out of business, and therefore, but when they go out of business, and Brandon, you surrender your stock, corporation's going to give you assets. And, see, another word for distribution could be simply, because I want to know which is not a distribution, another word for distribution could be simply payment. And when we give them stock, Cindy, what are we giving them? Pieces of paper. Which, and if you get, Brandon, if you got a 10% stock dividend, do you then get the champagne and celebrate and say, I'm now rich because I'm 10% richer than I was before because I own 10% more stock? So A involves a transfer of assets, B involves a transfer of assets, C involves a transfer of assets. So the correct answer, which is not a distribution, is D, as in David. Brandon, you agree?
Yep.
Now, Brandon, I chose this question because it is, I think, a difficult question. But notice, and when we started, it seemed you had no answer what the answer was. You had no idea what the answer was, but you could reason through it by identifying the one that was different from the other three. Which, Sydney, could make the difference, not in your case, because you're going to make in your case, it'll make the difference in making a 97 and 95. But for some people, it could make the difference in passing and failing the exam as to whether you can reason through the difficult questions. So, let's complete our discussion of corporations. Board of directors and officers and shareholders. Corporation is governed by a board of directors elected by the shareholders. Individual directors are not agents of the corporation. Only the board itself can act as a super agent and bind the corporation. And there's a reason, David, that we talked about agency before we talked about partnerships, before we talked about corporations. And there's a reason, David, that agency partnerships and corporations are grouped together in one tab, because arguably, Kelsey, this is all about agency. Corporate powers, express powers found in the corporation's article on incorporation, the laws of the state of incorporation, and so forth. Corporate bylaws may also grant or limit a corporation's express power. For example, let's suppose that let's suppose that the shareholders of the people, let's suppose the people that form the corporation are very environmentally conscious, and therefore could we write in the bylaws that the corporation has to be environmentally conscious? And could we limit the corporation from engaging in certain things which are contrary to environmental sustainability? And we could put that, we could limit part of the corporation in the bylaws and say you can't do certain things. Or suppose, Cindy, I had a sincere religious belief that businesses should not operate on Sunday. Could I put that in their bylaws? Didn't you know a corporation has done that? Chick-fil-A. Based in Georgia. Definitions. Authorized stock. The total number of shares that the corporation is authorized by the corporate charter to issue. Issue stock, the stock which has been issued by the corporation. That which treasury stock is that's which corporations buy back. So Linda, when we talk about treasury stock is when the corporation goes in the market and buys back its own stock. Who owns that stock? And why do we call it treasury stock? Is it owned by the treasurer?
No.
So who owns the stock? Nobody. Outstanding stock, issue stock minus treasury stock, and water stock. Delaney, do you still talk about this in intermediate accounting?
Marvell.
No, watered stock. Or watered stock is basically stock that is sold below par value. Thinking, does par value have any economic meaning? So I buy stock that has $10 par value. Does that mean the stock is worth 10?
No.
The stock could be worth 1,000. So does the par value have economic meaning? No. Now, Tellini, does it have legal meaning? Yes. What legal meaning does it have?
That it cannot go below, or you cannot initially sell below.
Okay, so one reason, in fact there are two reasons that the par value has legal value, has legal significance. One, dividends are often computed on the percentage of par value. So par value is used to compute dividends, to declare dividends. And also it's illegal in most states, including Missouri, to sell stock below par value. Megan, if I sell a bond below face value, below the par value of the bond, if I sell you a bond below face value, does that have economic meaning?
I get a discount.
Yeah, it gives you a higher effective interest rate. But if I tell you, if I were to sell you stock, Megan, below par value, that's selling the stock at a discount. Would the unsophisticated investor think that she's getting a better deal than she is?
No, she probably just thinks it's worthless. So the amount of the asset is less than what she's thinking it is.
Let's suppose that, Cindy, we have a $100 par value, and I sell you the stock for $80. Might the unsophisticated investor, I think Megan gave me an answer for sophisticated investor, might the unsophisticated investor think that she's getting a better deal than she has? Which is why, in most states, it's illegal to sell par value, the stock for below par value. Tellini, you agree?
Yeah.
So Cindy, do you talk about watered stock in intermediate accounting? Probably not, and probably not, why not, Michael, is that in most states, it's illegal to sell below par value, and nobody does, because it would be misleading. So, Tellini, why are we talking about it in here? It's, what? And also, it's a topic that comes up on the CPA exam. And, Kelsey, that one question about watered stock might be the difference in taking it over 39. Okay. Common stock entitles its owner to share in any dividends declared by the board of directors. It may be voting or non-voting. Preferred stock which has preference as to dividends and at liquidation. That is, they're paid before the common shareholders. First, shares are usually issued with a percentage, for example, 6%, 7%, 8% of par value. Note that Brandon preferred stockholders are not guaranteed a dividend. Might a preferred shareholder, unsophisticated preferred shareholder not know that? I think so. All they are guaranteed and what they're preferred, Brandon, is that they're preferred as to dividends and at liquidation over common. But what, Sydney, if we never declare a dividend? You got it. Definitions. Convertible preferred is convertible into common stock. Cumulative, which means that dividends are not paid, accumulate, must be paid out before common shareholders are paid. So, Kayla, let's suppose that we have preferred stock with a $100,000 par value and a 6% dividend rate. Now, Kayla, Cindy says that if we don't declare a dividend in 2013, that means that we're just out of luck. Unless Kelsey, it's cumulative. So let's suppose that there's no dividend for 13 or 14. So no dividend has been paid for 13 and 14. Kelsey, then, so that would be $6,000 a year. So, Kelsey, we say that dividends are in arrears by $12,000. Does that create a liability?
Yeah.
No, it does not create a liability because nobody's guaranteed the dividend. But, Kayla, what it does, if you're a common shareholder, before we pay you a penny, and it's now 2015, the stock is cumulative. The stock is cumulative, and we have not paid a dividend in 2 years. Before you get paid a cent as a common shareholder, you're going to have to pay Cindy, the preferred shareholder, $18,000. 2 years in arrears, $6,000 for 13, $6,000 for 14, and then $6,000 for 15. So I think, Sydney, that this does not create a liability. This simply means I've got to pay the dividends have not been paid before I pay the common shareholders. Kelsey, if it was a liability, that means I'd have to pay it eventually, but I don't have to because
Nobody's guaranteed.
and I don't have to declare a dividend. But Sydney, obviously if the stock is cumulative, does that make it more valuable? And therefore Michael, I can get more for it. If the stock is participating, Kelsey, help me with this. If the preferred stock is given a dividend rate of 6%, and I want to pay Kayla, the common shareholder, if I want to pay the common 7%, then Kelsey, that means that to be able to pay Kayla the 7, I've also got to allow the preferred to participate, which means they would also get 7. Okay. And Michael, if it was the preferred stock was participating, that makes it more valuable. And if it's cumulative, convertible, and participating, that would make it very valuable. And then unspecified, which means you get the dividend if and when we declare the dividend. So Cindy, as a preferred stockholder, you're sort of at the mercy of your common shareholders, aren't they? Although they're common people. Let the record reflect that I just told a joke and nobody got it. Or Linda says, I got it, it just wasn't funny. A director can also be a shareholder, especially in closely held corporations. And Jody, that would be fairly common. There are a few qualifications for required for directors. Anybody could be one. Election of directors. Although Kelsey, we could put in the bylaws certain conditions to be a director if we wanted to. Generally, the number of directors is set forth in the Articles of Incorporations. Directors are appointed at the first organizational meeting. In closely held corporations, directors are generally the incorporators and are the shareholders, and that makes sense. Term of office is generally 3 years, with 1/3 of the officers being elected each year. Candace, why is that?
So there's always a turnover of their board.
Well, one, there's always fresh blood, but two, each year we don't lose the institutional memory, so we don't have all fresh blood all at the same time. And that, again, is not required. Legally, it's just fairly common. Election of directors, removal of directors. Directors can be removed for cause. If there are vacancies on the board, somebody dies, resigns, or moves on. Quorum must be present to conduct official business, and we'll do an interesting case on that later. Committees of the board, executive committee, the audit committee, the nominating committee, compensation committee. And Sydney, this says something about our society, that we have a litigation committee. Directors have the following rights: the right to be reimbursed for expenses, the right to inspect the corporate books, because Sydney, if they can't inspect the corporate books, they can't do their jobs. The rely on reports and statements made by management. Sydney, is that important? Yeah, therefore, because if you're a member of the board of directors, if you can't rely on management assertions, then you can't do your job. They only have the right to be compensated if authorized in corporate bylaws. Sydney, is that surprising?
Yeah.
I mean, they could do it just for, why would they do it? Civic duty, or maybe to help out a family business, and maybe parents want to help out their children's new venture. But generally they are paid, but Linda, they can only be paid if authorized in corporate bylaws, which it usually is. Corporate officers and executives, officers serve at the pleasure the board of directors, but fiduciary duties to the company as well as to shareholders. Employment relationships are covered by contract and employment law, so they're simply employees of the company. Officers may be terminated for cause. David, provide an example, and then Megan, and then Brandon. We're given a situation where I could terminate, and David, is it good to be first?
Yeah, undisclosed conflict of interest.
Undisclosed conflict of interest would be a reason for termination. Megan, give me another reason.
Fraudulent activity?
I'm sorry, Shane? Fraudulent activity, okay. Brandon? What if we show up every Thursday drunk? Tuesday's okay, Wednesdays are a problem though. What if Brandon, the president of the company, has a sexual relationship with an intern? What's he got to do with his job? Or her job? Well, I think, Kelsey, it brings dishonor to the company. And if we can't trust him to behave in a responsible manner, we can't trust him. Sydney, but let me make this more sympathetic. Let me see if I can make, so we've got a president of the company having a sexual relationship with an intern. Let's see if we can make this more sympathetic to him. What if it was consensual? What if she started it? She came on to him. Alex is shaking her head, no, why?
Because it's still inappropriate.
Who is so inappropriate, and who's the adult in the relationship? A 50-year-old president and a 23-year-old intern. Should I give her a name? Cindy, most people will lost their jobs over that, wouldn't they? Directors and liabilities duties and liabilities of directors and officers. Their fiduciaries on the company ethical and legal duties, as you would expect. They have a duty of care, which means they have a duty to make informed decisions, duty to exercise reasonable supervision, duty of care. Dissenting directors rarely held individually liable to the corporation. Megan, what if you are a member of a five-member board of directors. And what if the board of directors has decided to change company policy and do A? And the vote to do A, whatever A is, was 4-1, and you were the minority, you were the one. And then Alex, she takes this information to the press. What do you think? Why did you do that? Obviously something you feel strongly about. But Sydney, does that breach her fiduciary duty to take her descendant vote to the press? Or, and Kelsey, maybe to answer the question, we need to know what the issue is, but in general, Kelsey, you could make an argument that she's doing what she should be doing. But probably AJ, which is certainly Megan's position, AJ, you're one of the four, what are you going to say?
Why are you?
What's up? And you're going to say that, is this bad PR? Is this bad PR? Kobe, what do you think? So probably she shouldn't do this? Do you think, Alex, it happens? Sure. Business judgment rule we've already talked about. Courts will not require directors or officers to manage in hindsight because hindsight is always 20/20. As long as the decision was reasonable, informed, made in good faith, in the best interest of the corporation, using dated information that we had at the time, not with the benefit of hindsight, director would not be liable, and otherwise, Brandon, nobody would serve on the board of directors. Duty of loyalty, subordination and personal interest to the welfare of the company, no competition with the corporation, no conflict of interest, no insider trading, no transaction is detrimental to minority shareholders. Kelsey and Brandon, why this concern with minority shareholders? Just suppose, Kelsey, that it's a family-owned business, and you, a non-family member, own 10% of the stock. So, it's a family-owned business, and it's been in the family for 3 generations, and Kelsey is run by the family, and you're a 10% investor. Brandon, does she know much about what's going on? Probably not. So why are we concerned about protecting her interest?
Because she expects, like, the majority.
So why are her interests, yes, suppose 60% of the stock, Brandon, is owned by the person who started the corporation 30 years ago. Do we need to protect his interest?
No.
No, he can protect his own interest. So Kelsey, what makes you more vulnerable?
Because minority shareholders can protect their interests and they can be taken advantage of more.
So, and is that consistent, Kelsey, with the law? For example, Kelsey, you remember from legal environment, landlord-tenant law tends to support the tenant. Employment law tends to support the employee because the power is, Brandon, is with the majority shareholder. Conflict of interest, full disclosure of any potential conflict, and to abstain from voting in any transaction may benefit the director, officer personally. However, if the conflict was fair and appropriate, it can be approved by a majority of the directors, Michael, not the shareholders. Liability of directors and officers, a shareholder derivative suit where shareholders sue the directors on behalf of the corporation. So Sydney explained this to me. And have you gotten to derivatives yet in financial Ford? Oh, fun. But here we're using derivatives in a different sense. So in what sense are we using the word derivative? And let me make sure I understand, Sydney, who is suing who?
The shareholders.
Shareholders are suing the board of directors not for themselves, but for the benefit of the corporation. So basically the argument, Kelsey, is that the board of directors is mismanaging the company. So shareholders are suing the board in the name of the corporation, not in their own names. So what's derivative about that? Kelsey?
Their power is derived.
Good answer. Their power is derived from the fact that they are shareholders. So again, Candace, the shareholders are suing the corporation, are suing the board of directors saying that they were mismanaging the company. So let's talk about business case 44, and tell me what the facts are, AJ. So we have a bank, and the bank has 3 directors. One of them is a lawyer. And the problem tells me, Jody, the lawyer handles all of the title work for the bank. And the title work, and is that a lucrative source of income for the lawyer? So every time the bank does a mortgage, you have to go do a title search, and you have to sign off like 500 documents prepared by the lawyer. So therefore, and this lawyer handles all the bank's title work. So that's a major source of income. And then there's an air conditioner contractor that has a contract with the bank. And then there is there's a third director. I don't know who she is. And then Tellini, we're trying to sell the bank. I don't know why we're trying to sell the bank, but we're trying to sell the bank, and we basically have, Tellini, do the names of the potential bidders matter?
No.
So let me just call number 1, so the bidders. Let me call them number 1, and have a column for position, and then action. And Tellini, by position, I mean the position of the bidder on the makeup of the board of directors. And Kobe, if you're the lawyer, do you want to stay on as a member of the board of directors?
Yes.
Because you want to keep that contract? AJ, if you're the one that has the air conditioning contract, and this is in Texas, so it's hot. If you're the one with the air conditioning contract, you want to stay on the board of directors because you want to keep that contract. And so, the position of number 1, I think, was
We would not retain it.
they would not renew. They would pick a new board. Tellini, what was the position of number 2?
They would
We'll
terminate.
consider it.
Yeah.
We'll terminate, but we'll consider. So if I've got this straight, AJ number 1 is saying, we're going to have a fresh new board, you people out. Number 2 says, well, we're going to terminate you, but then we'll consider putting you back in. And Tellini, the position of number 3 is
He said
no position. Which I think, Linda, may be the best position to be in, is to not take position on that question. And so, action number 1, what did the board do with the first bid? Nothing. What did the board do with the second bid? Nothing. What did the board do with the third bid? They rejected it. And then, Sydney, then one of the shareholders of the corporation brings a lawsuit against the board of directors. Sydney, what do we call that kind of lawsuit? The derivative lawsuit, because, Kelsey, their power derives from the fact that they are shareholders. And basically, they're alleging what, Tellini?
They're saying that they didn't do their job.
That the vice and AJ, that the board of directors are acting in their own best interest. Because instead of saying, Alex, well, let's see who's making the best bid, let's see who we can get the best deal for the bank and therefore our shareholders, Let's see who will keep us in our lucrative positions. Kobe, is that a good description of the facts? What do you think, Kobe, the likely outcome would be?
Shareholders will win.
Probably shareholders would win. So to avoid, Talini, you're in? So AJ, to avoid this, if you were given advice, because it just seemed like to me, Alex, that it seemed like to me that whether the board communicate this, whether they communicate it directly, certainly indirectly, they're saying, we want to make sure that we keep our position. That is, when the bank has new ownership, we want to be in the same position we're in now. And it seems like that imposes an improper, AJ, that imposes an improper condition. So AJ, what would you advise, if you give it advice, and of course, Kobe, who's going to win when this, and you're right, the shareholders will probably win, but as is always the case, Brendan, who really wins? The lawyers, because they get rich of the litigation. AJ, to avoid this, what would you advise them to do?
Either try to like get one of these bids back or pick some, like find a company that would buy us that would keep them on as the board.
But that's, oh, okay, so keep them on the board, but it seems like to me, Talini, that's what the derivative lawsuit is all about, is that you're putting your interest ahead of the corporate interest. Kobe, what would you advise them to do? And certainly, Kobe, AJ's advice is good advice if we want to protect the board of directors, but I think that's what the shareholders are complaining about. So Kobe, what would you have done to avoid the problem? Or is it unavoidable?
I think the way their stance and not taking these 3 bids into account is unavoidable now, from here out.
Yeah, but let's go back to the beginning before we got in the mess to begin with. Sydney, what would you do? Maybe, Sydney? I have an answer. I'll give you a
You
chance to
should,
give me
yeah,
one.
now you can go ahead.
I'm pausing. Make a note of pause. And then walk back and forth a couple of times to give her time to answer. Which only increases the pressure on her.
They should have accepted one of the bids.
Maybe. Or, how about this? How about Sydney? Well, which one?
The third one,
Why the third one?
since they didn't take a position, there is the possibility that they would.
But again, it seems like you're looking out for our interest.
But the shareholders don't have to know.
Did you hear what she said? Did you hear what she said? The shareholders don't have to know about this. Which, Brandon, is why the minority shareholders need protection. Did you hear what she said? Angela, did you hear that? Shareholders don't have to know everything. Which may be, Jody, what actually happens. And maybe, Cindy, the problem is that there's too much disclosure here. And maybe the bidders are telling us what they would do because we have telegraphed that we want to know that. So maybe we should have kept that off the table. Or maybe, Kelsey, what if we appointed an agent to handle the bids? An agent who's independent from us to filter the bids, and maybe, Michael, who would be a good person to appoint to do this? Would this be a good job for a CPA? I think so. Megan, what do you think?
So, on number 2, like, if they tried to renegotiate with the bidder and get it to like different terms, and the bidder said no, so then there was still no bid accepted, even though they put forth effort, would they still get in trouble from the shareholders?
Say again, yeah?
So like if they were to
Number two.
contact number 2, since number 2 is willing to consider it, and try to like negotiate something where a certain percentage of the current board could stay. And they put forth effort to like try to make a negotiation that's like better for both parties. And
When you
if
say
there's,
both parties, what both parties?
like the bidder and the current board.
But Kelsey's, whose interest is nobody considering here? Shareholders.
Well, no one, but like even if the bidder says no, and so there's still no bid, and there's a lawsuit, if the corporation tried, will they still get in trouble? They still put forth effort to try to come to.
So Talini, what's the basis of the derivative lawsuit? That nobody's considering the needs of the shareholders, and Sydney's approach is keep them in the dark.
So like the problem is basically only focusing on, like even now we're just talking about what is good for the board. So really the problem doesn't say anything about which bank should we sell it to for other reasons, for economic reasons.
And for example, there's no discussion of how much the bid is, how much money willing, how much are you willing, what assets do you have? What is your expertise in this industry, in this area? So it seems like there's too much focus on one narrow thing. And it seems like to me, Alex, what's good for the board should be one of the last things we think about. So my solution, Kelsey, is to appoint an agent who's independent from us that would consider all the pros and cons. And it seems like AJ, we could break this down into a simple cost-benefit analysis and say who's the best offer. Okay, interesting case. Joe, do you think this sort of thing happens a lot? And you think a lot of times the shareholders just don't know? And Kelsey, it could be that shareholders a lot of times don't care. And Kelsey, if the shareholders have been happy with the job the board's been doing, seriously, Kobe, maybe this discussion assumes bad faith. And maybe that's a bad assumption. I don't know. To continue. The role of shareholders. Acquisition of shares creates and grants an equitable ownership interest in the corporation. Generally, corporations have no right to manage the daily affairs of the corporation. And that makes sense because, Kobe, we can't have 100 people making decisions. 12,000 people. Controlling shareholders owe fiduciary duty to minority shareholders. And Sydney, we've already discussed that. Katie, anything to add? No. Kayla, Kelsey? Shareholders' powers include approving all fundamental changes to the corporation, attending articles of incorporation, amending articles of incorporation bylaws, approval of mergers and acquisitions, which we'll talk about next week, or next month. Shareholders' powers include sell of all corporate assets and dissolution, winding up, completely going out of business. Shareholders also elect and remove the board of directors who serve at their pleasure. Shareholders' meeting must occur annually, could occur more often. Voting requirements and procedures are notice of meetings, proxies. What's a proxy? Taylor, what's a proxy?
You tell somebody else to make your vote.
So I give you I know you're going to attend the meeting, so I give you my vote. So you have the right to vote my shares. Quorum requirement, shareholders representing more than 50% of shareholders must be present to conduct business. So this is a really interesting case. And as you read this case, Kayla, is this case more about, Kayla, it's as much about family law as it is corporate law, because basically you've got a fight between a husband and wife. So let me turn the lights on so I can diagram this better. Angela, zoom in up here. And tell me, basically, Kayla, tell me what's going on.
So there's a family-owned corporation, and only Gail case
5 shareholders. We have the husband who owns 20 shares. We have the husband and the wife who jointly own another 16 shares. We have shareholder number 1 who owns 16 shares, but he gave his proxy to the husband. So now the husband can now vote 36 shares. Then there are 2 other shareholders. Shareholder number 2 has 16 shares. Shareholder number 3 has 16 shares. And so that's how many shares outstanding? 68? 68 shares outstanding. And to be able to vote, we need a majority there. So the husband has his 20. He has the 16 that he owns, that has a proxy for, and that's only 36. The wife is not at the meeting. So the only one at the meeting, question whether you could call this a meeting. The only one at the meeting is the husband. The wife's not there. But he claims that they own this stock jointly, and therefore he's got the right to vote her shares. If so, if we can count the joint ownership, then he has a majority. And what does he do? He elects a new board, and he fires his wife as she was the secretary, the corporate secretary. He fires her for her position. So basically, he pushes her out. So what's going on here is that Sydney, this is a dysfunctional marriage that leads to a dysfunctional corporation. Okay, so let's answer the questions, and this is on page 790. So question number 1, Kayla, answer question number 1. Ask question number 1, Kayla, and then Cindy, you can answer it.
How many shareholders were present at the shareholders meeting that gave rise to this suit in this case?
1. 1 in person. And 2 by proxy. So Sydney, if he had the proxy of one of these other 2 people, he basically could have done anything he wanted to. Okay. So the central issue here is, again, Kayla, do we have a quorum, and therefore can we do this? Question number 2, let's see. Question number 2, AJ asked the question, and then Katie answered it for us. AJ, the question is?
How did the court categorize or classify the shares of stock that Kale and Sari Case held jointly?
So Katie, this 16 shares which are held jointly, the court said this was tenancy by the entirety. Tenancy by the entirety is a form of ownership only available to husband and wife. And the argument here is, Katie, that a married couple have the same economic interest. Therefore, Candace, if she were there, she would vote the same way her husband would vote. Now, Katie, in a normal marriage, is that true? But this is not a normal marriage. Question number 3. Cody, the question, and Talini, the answer.
According to the court, how many shares were represented at the shareholders meeting on the quorum present?
So therefore, the central question here, Talini, is does the husband have the right to count the 16 shares? Yes. Now, here's his argument. His argument is, I've got 2 questions to answer. Number 1, do we have a quorum? And the court said you can count the 16 shares because they only stock jointly, as tenancy for the entirety. Number 2, I did not vote the shares. And so Talini was saying that 1, I have a majority of shareholders, and number 2, a majority of those who voted for this. So it's a majority of a majority. Question number 4 was Jody and Matt. Question number 4.
Were the shares that Kale owned jointly with Shirley voted at the meeting? And how did the jointly owned shares affect the business conducted?
So I think man distinct to that question, because these questions sometimes run together in my mind. So, the 16 shares did count for the quorum, but they did not vote. So therefore, Matt, the court let him get away with this. And Katie, that's the way the wife would put it. Did you let that SOB get away with this? And both the district court and the Supreme Court, Matt, said yes. As a closing thought, you're familiar, Cindy, with the 19th Amendment, which was passed in 1920, which gave you the right to vote. You knew that, didn't you? An argument against the 19th Amendment giving women the right to vote, which was ratified less than a century ago, was that if you give Kobe women the right to vote, that gives 2 votes to married men. Because a wife is going to vote the way her husband tells her to vote. Was that a serious argument? We'll stop here and